So you tell me you forgot it, then you fess up and say you went to, ma'am, you drove into a pole. You had the whole city block closed down. You caused a whole city block to be knocked out for how long? Do you know? I went over there for breakfast one day and I couldn't believe it. Everything was shut down. Julianne McCormick, 260-646-78.
She drove her car into a utility pole, knocked out power to an entire city block, and walked into a courtroom thinking she could talk her way out of it. What she did not expect was a judge who had already done the math. And when he finished doing it, the only thing left in that room was the truth. And she was standing right in front of it. This case begins on a quiet morning in Michigan when Julianne McCormick got behind the wheel impaired. Not just impaired by alcohol, impaired by drugs. Her vehicle struck a utility pole with enough force to bring down a DTE energy tower, cutting power to the surrounding area for hours. Not minutes, hours. Businesses closed. Residents were left without electricity. The judge himself drove past the scene on his way to breakfast and could not believe what he was looking at. An entire city block shut down because one person made a decision that should never have been made at all.
This isn't the one that shut down all of Veterans Parkway, was it? Was it? Yes?
Yes, sir. I hit a power pole.
I know. I just didn't know if this was the same incident. I saw that was the area you struck a pole. Is anybody here from DTE? We sent them a letter for the record, the damage claims department on Haggerty on May the 8th.
The charge was operating while impaired due to the consumption of drugs. She pled guilty. That part seemed straightforward, but what unfolded inside that courtroom went far beyond a simple plea. Because McCormick had not just driven into a pole, she had driven into that courtroom with a story, and that story was already falling apart before she said a single word.
Yes.
So she pled to operating with while impaired due to the consumption of drugs. She was referred for a screening and assessment. Have you had a chance to review it, and are there any material additions, corrections, or deletions?
Judge, we've had the opportunity to review it, no additions, corrections, or deletions. We are asking, because of her schedule, and she works very hard, actually puts in more than 40 hours a week, in lieu of the court work program, if she could do some community service. And that is
the judge had ordered her to attend AA or NA meetings twice a week following her initial appearance. This is standard practice in drug-impaired driving cases. Courts use mandatory meeting attendance not just as punishment, but as a structured form of accountability. A documented, verifiable way of tracking whether a defendant is genuinely engaging with recovery or simply waiting for probation to end. Every meeting requires a signature on a form. Every form has to be brought to court. That is the system. It is not complicated. She came to court without the form.
And by the way, can I see your proof that you've been attending, or did you show it to your lawyer that you've been attending NA?
No, I'm sorry, I left it at home.
Why?
I didn't know I was supposed to bring.
Go get it. Okay? You're sure you got it? You're not going to come back here and tell me you lost it, the dog ate it?
Yeah.
Okay. Where do you live again? Go get it, or have somebody bring it to you. Okay? You're sure you're going to have it there? You're sure you're going to have it?
Yes.
Okay. Go get it.
very good.
When the judge asked to see proof of attendance, she said she forgot it. That happened to you before? You left something important at home that you absolutely should have had with you. Maybe it was a work document, maybe a permission slip, maybe a license. You know that sinking feeling. The difference is the stakes. She was standing in front of a judge who had already seen what her choices cost this community. He told her to go get it. Right then, she left the courtroom.
Yes.
As opposed to when? I told you when I gave you the form, when I told you to go to AA, and I tell everybody this, that every time you come to court, you have to bring the form with you, the signed form. Pardon? You didn't go to AA or NA, did you?
I do. I went to 2 classes.
I ordered this on May the 7th. I said, wait.
It's very good.
Wait. It's twice a week, I said.
Right.
That means 14, 21, 28, the 4th. You should have gone to at least 9 meetings by now.
And while she was gone, the full picture began to emerge. Her attorney disclosed that McCormick was already on probation. Not on probation from this case, from a separate case. Possession of an unprescribed controlled substance. She had been actively serving that probation. ordered by another judge in the 27th District, at the exact moment she drove impaired and destroyed that utility tower. In the legal system, committing a new offense while on probation is not just a separate matter. It is a probation violation. It means she now faced consequences in 2 courtrooms simultaneously. The judge's expression said everything his words had not yet said, getting more serious by the minute.
Judge, in addition to that, with all due respect, she is on probation in Wyandotte on a separate charge.
What's that for?
She had Adderall, which was unprescribed.
Was that another drug driving?
It was not, Judge. It was not. It was not.
So possession of an analog?
She came back without the form.
Yeah, I get it. It's getting more serious by the minute here. You're on probation. And was she on probation at the time of this defense?
That is correct, Judge. She was.
So she got to face a probation violation in front of Judge DeSantis.
Judge, I don't know if there was a show cause hearing. Not aware of it.
But she was.
In fact, she's indicated to me that there has not been a show cause hearing.
Were you on probation at the time of this offense?
Yes, and I told my probation officer, and she said, let me know how it goes.
Well, it's not going to go too well.
She admitted she had only attended 2 meetings. She had been ordered to attend twice a week since May 7th. The judge did not lose his composure. He did not raise his voice. He simply counted. May 7th, twice a week, 14, 21, 28. She should have attended at least 9 meetings by that date. She went to 2. Then she came into his courtroom and initially implied she had the documentation to prove otherwise. That is the moment. Read it again slowly. She implied compliance. She did not have it. She had gone twice. That is not someone who forgot a form. That is someone who hoped the judge would not notice. He noticed.
So you tell me you forgot it, then you fess up and say you went to, ma'am, you drove into a pole. You had the whole city block closed down. So you're not going to take this seriously. If you're not going to take this seriously, you and I are not going to get along.
Can't take it very seriously.
Well, you can't be because you didn't comply with my order.
It's really hard for me to do it because I work after.
The judge then dismantled her attorney's claim that her work schedule made attendance impossible. She reportedly worked up to 7 days a week. The judge walked through the arithmetic publicly. In open court, base pay, overtime at time, and a half on Saturdays, double time on Sundays. He concluded she was earning over $300 on a single Sunday shift alone. His point was precise and devastating. This was not a person without resources or time. This was a person who had made choices about how to spend both.
What days do you work?
She was Mondays through Fridays.
Sometimes 7 days.
Then you're making a lot of money. How much do you make per hour? You get paid overtime when you work Saturday and Sunday? Yes?
Yes.
That's $33 an hour on Saturday? Yes? How much you make on Sunday? Double time? Or not? So you're making $44 an hour. So you're making $320. You're making $342 to be there on Sunday.
Now ask yourself this. If someone in your workplace missed 9 mandatory training sessions, showed up without the required documentation, and then suggested their job made compliance impossible while pulling overtime pay, would they still have that job? Would the rules bend for them? Or would the rules only bend because no one was counting? Someone was counting.
You're not really working 7 days a week. You're telling me 7 days a week because you want to cover the fact that you haven't been to AA or NA.
I work 6 days.
If I catch you lying to me,
No, I'm not lying.
no, ma'am. When I catch people lying to me, that tells me they have no.
Lips.
Do I have to go so far as to have you bring your pay stubs to me? Do I really have to do that?
Here is where the legal education matters. Under Michigan law, a defendant on probation who commits a new offense does not simply get sentenced for the new crime. The original probation can be revoked entirely, and the defendant can be ordered to serve the original suspended sentence. She was exposed on 2 fronts simultaneously. The new judge could sentence her. The original judge, Judge Dano, could revoke her existing probation. She did not fully seem to understand how exposed she was, or she understood and was hoping no one would connect the dots in real time. He connected every single dot.
Make it monthly thereafter. You're going to attend AA, NA, or any combination of AA, NA, and a fan meeting twice a week. until you're in an intensive outpatient treatment program. I'm ordering intensive outpatient treatment. Once you get into intensive outpatient treatment, you no longer have to attend AA or NA as far as I'm concerned. Whatever Judge DeSano's ordering, you have to follow her order too. You understand that? I'm also ordering the victim's impact panel that is one night that is put on by Mothers Against Drunk Drivers.
The sentence he handed down was firm, but some would argue still measured.
I'm going to place you on probation for 15 months. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal controlled substances. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PBTs and ETGs, and I do not want you to fail, but I'm getting concerned now. Weekly for 3 months. If you're clean, I'll make it bi-weekly for 2. If you're clean, I'll make it monthly.
15 months of probation. Weekly chemical testing for 3 months, stepping down based on compliance. AA or NA twice weekly until enrollment in intensive outpatient treatments. A victim's impact panel run by Mothers Against Drunk Drivers. Community service. Court work program days in lieu of jail. Fines and costs totaling over $1,300. She did not go to jail that day.
Judge, I believe she's going to be successful. She's, because of her mental health issues, these are prescribed medications. No excuse, but nonetheless, medications that were used were prescribed on that horrible day.
She's taking something else that wasn't prescribed, right?
I didn't take that.
On probate, when out of the wind-up case.
No, what the judge is referring to the day, it was in her pocket, Judge, but nonetheless, she should have.
She wasn't carrying around in her pocket not to consume it or ingest it.
Here is the question worth sitting with. A city block lost power for hours. A woman was actively violating one probation when she committed this offense. She missiled the court about her meeting attendance, and the sentence was probation. Was that justice? Or was that a system doing the minimum it was designed to do?
I don't want to set you up to fail, okay? But you got to be careful here. The driving pattern here, everything I saw scares me.
Some cases teach us that the courtroom is the last place where accountability cannot be purchased, negotiated around, or delayed indefinitely. Not because every judge is perfect, but because the best ones count. They count the days. They count the meetings. They count the math on a Sunday paycheck. They count the ways a story does not add up, and they say so out loud, in a room where everything is on the record. That is what accountability looks like when someone actually exercises it. If you know of a court case or a courtroom confrontation that you think deserves this kind of scrutiny, drop it in the comments below. Subscribe and share this video, because an informed public is the only public that can hold any system to account.